On behalf of Michael Green and those of us on Green List, I'd like to welcome you to our CPD breakfast seminar this morning, which has the title of Protecting Employer Goodwill from Attack. I'd also like to congratulate you on getting up on this wintry morning and making your way here. It was certainly difficult for a few of us here before you, myself in particular. Before I introduce the speakers, if I can just give you a very brief rundown on how we propose to conduct things this morning. You'll firstly hear from two of our speakers, firstly Carmen Currie and then Angus Galbraith, who will speak on their respective areas. We'll have a brief tea break at around 5 or 10 past 8. We'll then have our third speaker, Alanna Duffy, and then a question and answer session, and hopefully we'll have you out of here at around 8:45 or 10 to 9 this morning. Can I just say, before I introduce our first speaker, Carmen, I've been working in this area for around just over 20 years now, over 10 years at the bar as a barrister, and in my experience is usually acting principally for employers, there's nothing which angers and frustrates employers more than having situations where they regard current employees, or usually former employees, as having done the wrong thing and tried to essentially sabotage their business. And it can extend from all sorts of conduct to when the employees are still in their employ and laying the groundwork for their future business activities, either on their own account or working for competitor companies, to the activities of those individuals when they're no longer their employees and at the competitors, and doing things which the employers regard as completely improper and unlawful, such as poaching clients or seeking to entice employees away to join them in their new venture. And often, one of the difficulty that we as lawyers face when advising our employer clients in that regard is to hose down their expectations, and in particular their expectations of what relief, if any, the courts can provide to them. And it's in that context that the three topics that we're looking at today, those of restrictive covenants, confidential information, and the fiduciary obligations which are owed by former employees to their employer, are particularly relevant. Our first speaker this morning is Carmen Currie. Carmen joined the bar in May 2011 after having worked for over 9 years as a litigation lawyer at Holding Redlich. Her particular or key areas of practice are employment law, commercial law, administrative law, and also in criminal law, with a particular emphasis on corporate prosecutions. In the field of employment and IR, Carmen acts for employers in OH&S prosecutions, coronial inquests, and other regulatory investigations. She appears in fair work matters and has a special interest in the area of restraint of trade disputes, particularly having appeared for the defendant in a very recent Victorian Court of Appeal matter of Wallace nominees and Pickett. No doubt you'll hear about that this morning from Carmen. Carmen will speak to us this morning on restrictive covenants.
Thank you, Joseph. I'm really pleased to be able to speak to you this morning about employment restraint covenants. I think it's one of the most interesting areas that can arise in this field and employment disputes, and in the 15 minutes I have with you, I thought what I'd try and do is just cover off perhaps the three key things that you need to know about employment restraint covenants. So what am I referring to when I talk about a restraint covenant? For the purposes of today, I want to focus on those terms in employment contracts that seek to restrain an employee from working somewhere else or for someone else after they've left their employment. It would also include a term which would seek to restrain an employee from soliciting existing clients or soliciting work within a geographic area after they've left their employment. You'll hear a little bit more about other types of restraint covenants from Angus and Alanna in the context of protecting confidential information and trade secrets, but for the purposes of the 3 points I want to go through today, I'm focusing on those post-employment restraints. So the first and often the most surprising key thing to know about employment restraint covenants is that at common law they are prima facie void and unenforceable. For most of us that's not necessarily a surprise, but for many employers that can be a cause for some great dismay once they've seen a term or a clause in a contract signed and inked by both parties. It can come as some surprise to find that it's prima facie one that they can't enforce. There are long-standing public policy reasons for these types of terms being treated, first of all, as void. And really that comes from an attempt to balance the interests of the freedom of the individual to enter into any contract that they like against the public interest in maintaining mobility of labour, fair competition, and to avoid essentially the threat of an indentured workforce by virtue of people being bound not to work or not to compete with a former employer. The rationale for it, there's an expression for it which goes back about 100 years but is still cited in cases today, and it comes from the Herbert Morris and Saxelby case of 1916. There they said that the rationale for this voiding of these types of covenants is that every man shall be at liberty to work for himself and shall not be at liberty to deprive himself or the state of his labour, skill or talent by any contract that he enters into. And of course that extends to our female workforce as well. So that's the first and perhaps the most important thing to know about post-employment restraint covenants. Prima facie void and unenforceable. But even though it is prima facie void, it may be enforceable if the employer can justify that it protects a legitimate business interest and that the covenant does no more than is reasonably necessary to protect that interest. So that brings me to number 2 thing to know about employment restraint covenants. To be enforceable, the onus is on the employer to show that the restraint is designed to protect a legitimate business interest of that employer. So what classifies as a legitimate business interest? Well, I'll start with the 2 things that are not legitimate business interests. And again, these can sometimes be a surprise to employers. The first is this. The desire to protect your business from competition, per se, is not a legitimate business interest. The common law recognises that competition is a natural part of the marketplace, and that alone is not sufficient reason to try and stop an employee from going to work for a competitor. If the sole purpose of an employment covenant is to try and outdo a competitor in the area, then it's unlikely to be enforceable. The second thing, which is often a surprise to people, and which is not a legitimate reason for a restraint covenant, is this. It's not justifiable to try and stop an employee from using the skills, reputation and experience that they've gained in the course of their employment from pursuing their career elsewhere. The skills and knowledge, putting to one side perhaps confidential information and trade secrets, which are treated differently, the general skills and knowledge that an employee gains in the course of their employment are not an asset or interest of the business, and the employer is not entitled to restrain a person from using that skill, knowledge, reputation elsewhere. So what are legitimate, protectable interests that can justify a business from restraining an employee? Well, there are a few recognised categories. In general terms, these are interests or assets, if you like, of a business that are vulnerable to misuse or abuse by an employee by virtue of the position that that employee has held, or their role, or the information or contact they've had with clients in their job. In the materials you've been provided today, I've included a paper which sets out in perhaps a little bit more detail some of these categories and some of the cases that have dealt with them, but I'll just run through 3 of them in very general terms this morning. The first and most common interest that can justify a restraint is the interest in protecting your business's connection with customers. And a restraint can be a justifiable means of protecting that connection from misuse or abuse by a former employee. Customer connection will generally only arise as an interest if you're dealing with an employee who, by virtue of their role, has some sort of special, particularly strong or special connection with your customers that puts them in a position where essentially they become the face of the business to that customer, or they're able to control the customer or client's business with the employer as if it was their own business. Some examples of this might be, and I'll give an example from a recent Court of Appeal case of Bird & Co, an accountant employed by an accountancy firm who looked after the accounts of a business over several years, and from the customer's point of view, that one accountant was the person who they valued the most in that business, who understood their ins and outs better than anyone else, and that had a very strong connection with that accountant. When that accountant left and set up independent business in competition with the former employer, a restraint provision was exercised to try and prevent that accountant from using their quite considerable sway over that existing client to take that business to his new enterprise. Another example from the Wallace Nominees and Pickett case, which Joseph mentioned, was an IT consultant who worked for a business that was in the... what it would tend to do is contract out IT experts to various businesses around the city for project work. One of its IT consultants was contracted to a construction business. He was there for 3 months initially, that became 6 months, it became 12 months, and over that time that individual within the customer's business became expert in their internal systems, very well known to the staff at the customer's business, and was perceived to have developed, there was perceived to be a real risk that that consultant could control the customer of the contracting company as if it was their own business. Customer connection is probably one of the most common legitimate interests you see in this field as a justification for a restraint, and it's interesting if you look at perhaps those 2 recent Court of Appeal cases, Bird & Co and Wallace and Nominees, and they're cited in the paper if you want to have a particular look at them. There seems to be perhaps an increasing willingness to recognise customer connection as a justification for a restraint by our courts. Another example of a legitimate interest that can justify a restraint is staff stability. So that this is a situation where a business has a recognised interest in keeping a stable workforce, and so if the departure of an employee is likely to result in that employee attempting to poach other staff to go with them, then there may be a justifiable basis to attempt to restrain that employee from doing so. There's a New South Wales case of Cactus Imaging and Peters, again referred to in the paper, where a business was entitled to restrain a former manager from poaching, if you like, former staff of that business to leave with him and go somewhere else. A third and fairly recently recognised interest is one that has particular application for labour hire firms or contracting firms, and it comes from a federal court decision of Informax, which is also known as the Candle case. And in that case, Justice Perham in the federal court recognised that labour hire firms who are in the business of matching up job seekers with businesses that are looking for contractors or staff and who make their money by being the middleman, if you like, Justice Perham recognised that those businesses have a legitimate interest in protecting their cut, if you like, protecting their middleman profit that comes from matching up job seeker and client. And a restraint is one way in which those sort of businesses may be able to protect themselves against job seeker and client going off separately, contracting together and cutting out the labour hire firm. Justice Perham calls that interest opportunistic disintermediation, a term which comes from the US where it's been recognised for some time. And that too is quite an interesting case to read, if only because of Justice Perham's ability to make restraint doctrine read like Jane Austen. It's quite an entertaining decision. The final key thing to know about employment restraints, number 3, to be enforceable, a restraint provision must do no more than is reasonably necessary to protect the employer's legitimate interest. If it goes beyond what's reasonably necessary to protect the identified interest, it's invalid and unenforceable. And the question of what's a reasonable restraint is ultimately a question of law to be determined by a judge. And it's in that process regard will be given to a number of factors. And it's often at this point of reasonableness that restraint covenants come unstuck. The various things that will be given regard to include the following. What is the nature of the restraint? What is it that this employee is to be prohibited from doing after they leave their employment? Are you restraining them just from doing the same sort of work or providing the same sort of services that they provided in their employment with you? Or are you trying to prevent them from providing a broader range of services? If you stray beyond what that employee had been doing in their ordinary job, you're likely to get into a realm where it's unreasonable to restrain a person from doing some other quite different sort of work, even if it might be in competition with you. Who does the covenant prevent them from working for or from providing services to? Is it limited just, if what you're trying to protect is customer connection, is the restraint limited to just those customers that this employee did or was likely to have contact with and therefore have that sort of sway over? Or does it reach further than that? Are you stopping them from having contact with any client of your business regardless of whether this employee had any contact with them? Again, it's an area where quickly a restraint covenant can become unreasonable if you're preventing an employee from working for clients or customers who they've had no real connection with at all. How long is the employee to be restrained from the prohibited activity? The time period of a covenant is key and is often a point where these fall over. And is there a geographic limit to the restraint? Again, it's always got to come back to what's the interest you're trying to protect. So if you're dealing with an employer or a business that's Melbourne-based, then it's immediately going to appear unreasonable to prevent your employee from working with a customer or a client who may be in Sydney or Brisbane or overseas. So real regard has to be given to how far your covenant needs to reach to do no more than to protect the interests that you have. Courts will also have regard to what impact the covenant has on the ex-employee. Will it in practical terms mean this person can't go and earn a living? Will it mean that they have to leave the state or move cities in order to continue their career or continue their trade? Those are considerations the court will take into account. They'll also look at things such as, can the employee get around the restraint by paying liquidated damages? That was a factor taken into account in the Burden Code case, where the Court of Appeal saw there was an option in this contract that if the accountant wished to provide services to a former client, it could pay a fee or liquidated damages to the former employer. And that was seen as a factor in considering the impact of the covenant on the employee. There's an interesting question about how you assess the reasonableness of the time that a covenant is to apply to a former employer for. For customer connection issues, you might look at how long that ex-employee's sway over clients is expected to hold. How long until their ability to control the custom of the client has diluted is one way of formulating the test. Another way of measuring what's a reasonable time period would be to look at how long the employer needs to find a replacement employee and to allow that replacement employee to build or develop that customer connection. In the Wallace and Nominees case, this is the IT consultant who was placed into the construction company for a period of time. The court looked at the time period of that restraint, which was 12 months, and said, that's unreasonably long. That's much longer than you need to put a new IT consultant into that business and allow them an opportunity to develop customer connection. It's much longer, the court said, than you would need for the sway of that IT consultant to dissipate over the client. In contrast, in Burden Code, which is the accounting case I was telling you about, there was a 3-year period of restraint on that accountant working for a former client, and the Court of Appeal held that that was a reasonable time period, having regard to how long it would take for the influence of that accountant to wane. So I think that brings me to my time limit. Those are the 3 key things that are useful to know about employment restraint covenants. First of all, prima facie, void and unenforceable. Secondly, onus is on the employee to show that there is a legitimate interest that justifies a restraint to protect it. And third, for it to be enforceable, the restraint must do no more than is reasonably necessary just to protect that interest. Thank you.
In my experience, when we're dealing with the enforceability of restrictive covenants, you're usually dealing with the issue at the interlocutory stage when an employer is seeking to enforce one of those covenants, or alternatively an employee is trying to resist it being enforced. And as Carmen has indicated, there are certain matters which the courts take into account. And one of the more important ones in my experience are the particular factual circumstances at the time. Usually when you're dealing with the enforcement of restrictive covenants, you're not dealing with those in a vacuum. There's always a particular factual context. And in many instances, you have a situation where not only are you dealing with the enforcement of a restrictive covenant, but there are also allegations that the employee concerned has either breached their duty of confidentiality in terms of having disclosed confidential information, or having breached their fiduciary duties as an employee. And those are the sort of factual matters which the courts will always do take into account in considering the enforceability of restrictive covenants. And they're the 2 areas we're going to move on to now. Our next speaker is Angus Galbraith, and Angus is going to speak on the topic of confidential information. Angus practices principally in the areas of commercial litigation and employment and industrial relations matters. In relation to his employment IR practice, Angus provides advice and also undertakes appearance work in areas involving common law and contractual claims, unfair dismissal, unlawful termination, general protections or adverse action claims, breaches of legislative and industrial instrument obligations, enterprise bargaining, enforcement of restrictive covenants and restraint of trade provisions, and discrimination, harassment and occupational health and safety. Before coming to the bar, Angus worked in the litigation and workplace relations areas of a medium-sized Melbourne law firm, and during that period of time he acquired broad experience in all the areas I've mentioned, providing advice to not only medium and large-sized corporations but also to individuals and religious and not-for-profit organisations. As I said, Angus will speak to us this morning on the topic of confidential information.
Thank you, Joseph, and good morning, everyone. As was indicated, I'm going to be talking on confidential information this morning and the various manner in which that can be protected or sought to be. The rights to protect can be enforced by employers. There's a short paper which I intend to elaborate on as I go through, and as I think Joseph's comments as he opened up this morning are very important. This is an area where employer clients often come to you and there's a lot of anger because of the belief that certain information and certain practices must certainly breach various duties or obligations on the part of employees, particularly when they depart employment and take either clients or actual information away. And often it's important to control and manage expectations in these areas because the moral rights, I suppose, with respect to what you might believe someone's done is a bad thing, don't always translate into the legal rights of enforcement that we are talking about today. Principally, confidential information can be protected. Well, the most common we think about are the implied contractual duty of fidelity. Sometimes it's referred to as the duty of loyalty and fidelity or good faith or any combination of those three things in different texts and different judgments. There's also the equitable action for breach of confidence and obviously express contractual obligations like restraints of trade, confidentiality clauses principally that are included in employment contracts. There's also some statutory sections in the Corporations Act, Section 181 through to 183. Principally, Section 183 deals with confidential information, but there's a tendency of the courts not really to take those obligations any further than the equitable obligations that exist in relation to breach of confidence. So with respect to dealing with the duty of fidelity first, it's pretty well settled that the common law imposes a duty of fidelity upon all employees. And the duty arises from the relationship of employer-employee under the contract of employment. But there's also, it overlaps a little bit with breach of the action for breach of confidence in that the nature of the relationship itself. Also, the fiduciary obligations that can be created in that relationship can also give rise to or be a basis for the duty. The practical difficulty in any case with the duty of fidelity is, whilst it's easy to talk in absolutes and say this duty exists, is how far does the duty extend in a particular case? And there's old authority, I think, from English lords in cases that have described it as rather vague as a duty and things such as that. So the question becomes, how far does it extend in a particular case? And the content of the duty will invariably, or will vary according to the position that the respective employee holds. Generally, a more senior employee, greater access to confidential information or similar things, will be subject to a greater restraint by the duty than a lower class employee who doesn't have similar levels of access. Whatever its total encompass is, it's been applied consistently so as to condemn in damages, and also by way of injunction to restrain an employee who subverts the, I would say, his employer's business in furtherance of his own interests. The duty itself, in the context of confidential information, often it's broken up into distinct areas you might have heard about. There's an obligation not to make secret, no bribes or secret commissions. Another one is no solicitation of customers and goodwill. But in the context of confidential information, the duty of fidelity requires that an employee must not use confidential information obtained in the course of his or her employment to the detriment of the employer. Now, the issue is that it only attaches to what is truly confidential information. Not all the knowledge, skill, experience or information that an employee has collected during employment will come within that concept of truly confidential information. And that's, in a moment I'll come to talk about exactly the classification of what is truly confidential information, but that's often where difficulties arise in these matters. Is confidential information, or it's hard, can be inseparable, bound up within the employee's general experience, and there can be real difficulties specifically identifying what the confidential information is. The other issue with trying to rely on the duty of fidelity is that there's some doubt how far the implied duty extends beyond the cessation of the employment relationship. There's been a suggestion that it can continue in a more restricted fashion, although there seems to be in the Australian judicial preference seems to be that after employment to revert to the equitable principles with respect to restraining the use of confidential information. And the authorities seem to suggest that it arises out of the basic principles relating to the implication of terms in contracts. These ideas of business efficacy and necessity, and arguments that for those reasons it's not absolutely necessary for the term to exist beyond the cessation of the agreement in light of equitable duties that exist also. One thing I thought would be interesting to comment on at this stage is that in executive contracts and the like, sometimes you see gardening leave, or situations where there is an entitlement for the employer to send the employee away from the workplace, albeit they continue to pay them, to restrain them in a sense from immediately departing the employer, to control their activities. During those circumstances, the duty of fidelity, of course, would continue to exist. It's really after the relationship ceases that this question about does it continue as an implied contractual duty comes up. The next way is the action for breach of confidence. Now, the principle is that the court will restrain the publication of confidential information improperly obtained, or of information imparted in confidence which ought not to be divulged. Now, for protection under the action for breach of confidence, the information must satisfy what are 4 requirements. Paragraph 7 of the paper, it's indicated to you. The information must be specifically identifiable. The information must have the necessary quality of confidence about it, is how it's been described. It must have been imparted in circumstances importing an obligation of confidence, and there must have been an actual or threatened unauthorised use or disclosure. The benefit, as I've indicated before, and perhaps why there's a judicial preference to be more inclined to find positively that there's been breaches of confidence is that it is an obligation that continues after employment ends. And the majority of these sorts of cases do involve employees who have departed and taken trade secrets or something such as that. Most of the time you're dealing with post-employment situations, not situations during employment. So that's why breach of confidence, in my view, assumes more importance. The remedies available for a breach of confidence are also more extensive than for a breach of the contractual duty. I mean, we're talking about equity. So a party who breaches this obligation can be held to render an account of profits derived from the misuse of the information. And additionally, unlike the contractual duty, an action for breach of confidence may be brought to restrain disclosure by a third party who has received that confidential information as a result of the breach of confidence. Those are also added benefits to the action itself. So having considered those two things, it brings us to a point where we sort of have to ask, what is confidential information? And the courts, on my reading of a lot of the decisions, they're careful to restrict the expansion of the categories of information that can be protected as truly confidential. One of the often cited authorities for identifying, or the questions, the list of factors for identifying confidential information is Wright and Gaswell, which was a decision of Currie before he went to the High Court. And it set out a list of factors for identifying truly confidential information. And one of the very important ones that you see in the cases is how much skill and effort was expended to acquire the information. So if you think about an employee preparing to departure, and they're taking active steps to collate certain information of an employer, the more effort they expend to do that, the more likely the information is to be confidential. So if it involves elaborate copying of computer hard drives or taking notes of specific formulas to do with commercial products, things of that nature, it's more likely it suggests confidentiality exists. A lot of effort in requiring the information suggests confidentiality. The other thing is, has an employer jealously guarded the particular information? Obviously, if they haven't, it's unlikely to be confidential. If they've treated it as such, then that will be an important consideration. Did the employer communicate the nature of the information to the employee? And that's an important thing that we'll come to in the context of contractual obligations as well. But that is another aspect of the test that the courts will look at. Industry practices in regards to the particular confidential information is another point that will be looked at by the courts. And in terms of, it touches on the jealously guarded factor, but has access to the information been restricted only to senior staff? Obviously, internally, within an organisation or an employer, if it's widely disseminated, it's less likely to be confidential information. Now, as I noted earlier, it doesn't always extend to include the stock of knowledge, skill and experience that the employee has gathered over the period of their employment. Often the general, what's described in a lot of the texts and by commentators, the general know-how of an employee is inseparably bound up within their stock of knowledge, and very difficult to, in practical terms, it's difficult to isolate from everything else they know. Some examples of confidential information is lists of clients and contact details, price lists, costing information, market research data, sales and marketing plans, things of that nature, provided they meet those requirements in the specific circumstances of a case. That sort of information can be classified as confidential and protected under the duty or the action for breach of confidence. Now, the final area, and an area where I think employers are best advised, because it's more in terms of their ability to protect themselves, be more proactive than reactive, like the other two actions that I've just discussed, is express contractual obligations. Now, we've all heard about confidentiality clauses, and often they're included in contracts of employment. Indirectly, confidential information can also be protected by restraint of trade clauses, which Carmen discussed, by restricting who an employee can work for and then invariably who they can tell various things. The other benefit of the contractual provisions is you're free to draft the clauses such that it specifically identifies the information that you want to be the confidential information. So in that respect, you're not as restricted as the common law is with respect to identifying truly confidential information. For example, if you're an adhesives manufacturer or in adhesives production, you can specifically identify your product that you want to include as confidential information, or the makeup, the formula for that product in the contract or in some document you incorporate by reference and provide to the employee. And that provides because the courts are slow to say it's not confidential in circumstances where the parties have identified it and agreed that it is. So that's a real benefit of the express of contractual obligations. The other side of the coin is that unfortunately employment agreements are often pro forma agreements that are flicked out, including restraints and various other confidentiality clauses that aren't tailored to particular situations or are described generically. And in circumstances like that, the ambiguity is going to be interpreted against the interests of the party seeking to enforce it, and the consequences of that are that it's the common law will assume greater importance, and you will have the ordinary difficulties in establishing whether information is truly confidential. That's my time, I think. So thank you very much.